paid a premium for that. In addition to that, premium adjusted the premium for $10,000 in medical payment coverage. We had a damage hearing back on October 7th, 2014. The damages were the result of Ms. Austin being injured by a never apprehended hit and run uninsured driver. Her injuries just real briefly were she had a couple pelvic fractures, one displaced, a broken sacrum, severe concussion, and we had submitted Dr. Cottage's deposition for your review. At that time, we had argued the damages from Ms. Austin based upon the permanency of her injuries and her age were in excess of $250,000, and we asked the court to enter judgment for $100,000, which was the policy limits for the uninsured motorist version. At that time, the defendant didn't argue for any credit or set off for any Medicaid, and if you recall, Your Honor, at that time, the plaintiff was ready to proceed and argue a qualified settlement offer of prejudgment interest, and we all kind of agreed it was prematurely set a date in the company.
Okay.
That was the case, and that's why we're here.
All right.
On October 22nd, the court entered the judgment for the $100,000, and then I filed my motion to enforce the qualified settlement offer and to seek prejudgment interest. In the basis of it, Your Honor, is in February 21st, 2014, and this is all attached to our motions, I filed a written qualified settlement offer that invoked the prejudgment interest statute for $100,000. And I think the defense makes a good point in the fact that with regard to the qualified settlement offer, where we were seeking $1,000 for attorney fees and expenses, the only way we could get that is if the award was less favorable to the defendant than what we demanded. And because they're the same, we agree, we're not entitled to that $1,000.
Okay.
So I think the qualified settlement offer is really moot at this point. However, the prejudgment interest, pursuant to statute 345146, does entitle us to prejudgment interest if we meet certain requirements. And as the court realizes, and the Court of Appeals has acknowledged to subsequent cases, the purpose of the prejudgment interest statute is to encourage settlement to account for time value of money. And specifically in the Inman versus State Farm case, which is 981 Northeast 2D1202, that's the Indiana Supreme Court 2012 case. That case stands for the rule of law that the plaintiff's entitled to prejudgment interest against its own insurance company, even if it requires the company to pay more than the statutory the policy limits. And in this case, the plaintiff has met the statutory requirements. We did a $100,000 demand in writing within 1 year of the filing of the suit, and we obtained a judgment that was at least 75% of the demand. We beat it. We were only required to get $75,000 for prejudgment interest. The court awarded $100,000. Pursuant to the statute, the court has the discretion to award between 6 and 10%. And what we've done, judges, in the court motions, and I'll go through it right now, we've asked the court to award 8% because we think that's in the middle. We could ask for 10%. I know the defense is asking for 6%. We think 8% is fair and reasonable. And the way the prejudgment interest is computed, the defendant gets 15 months credit from the date of the crash, which was January 20, 2013. So when we add 15 months to that, the prejudgment interest would start to accrue on April 20, 2014, and they would run up until the date of the judgment, which was October 22, 2014, or roughly 190 days. If the court were to award 8% as we're requesting, basically that computes down to $21.92 per day for a total of $4,164. And that's what we're asking for with regards to the judgment interest. Through their motion, the defense has argued that if the court awards, it should only award 6%, and there's really no basis. The bottom line is 8% is fair, and it's totally up to the court's discretion. Now, in response to our motions, and this is where some of the other motions kind of play together, the defendant insurance company is arguing that because they made a verbal offer of $75,000 the week of the damage hearing, that precludes us from getting prejudgment interest. And by way of background, I think it's important, and I filed this with the court through my motions. Back in February 28, 2014, as a matter of fact, the defendant insurance company had actually sent us a QSO for $25,656.25. And as I said, on the week of the hearing, they made a verbal offer of $75,000. But the bottom line is that doesn't preclude prejudgment interest. The fact that they offered $75,000 verbally the week of the hearing isn't any shortcut for them to try and preclude us from receiving this. And what the defense should have done, and there is a statutory provision that would give them protection if they want to protect themselves from prejudgment interest, and I think that's what they're trying to do by verbally offering $75,000. And that statute is 34-51-4-5. In pursuant to the Indiana law, they can make a written offer, which is at least 2/3 of the judgment, which means if they would have made a written offer of $75,000, that's one of the ways they could protect it. However, if you look at the statute, that written offer has to be made within 9 months of the suit being filed, which means it would have been made in writing on July 22nd, 2014. The defendant did neither in this case. It didn't offer $75,000 in writing, and when it did verbally offer, it was the week of the trial. Therefore, the statute doesn't apply. It doesn't provide any protection they seek. The defendant, in its response to my motion, has argued that it is entitled to a credit, a set-off for medical payments, or later argues that it's entitled to a Med-Pay lien in the amount of $7,750.25. First of all, with regards to the set-off of credit for payments under the Med-Pay, I would argue that issue is waived. It should have been brought up at the damage hearing when Your Honor was determining the amount of damages to be awarded pursuant to the uninsured motorist policy. The defendant chose not to make that argument then, and therefore it's waived. However, even if we get beyond waiver, Indiana law is very clear that the court must look to the language of the policy as written by the defendant insurance company to determine if the defendant's entitled to the set-off of credit. In that case, is Wagner v. Gate, and that's 912 Northeast 2D 805, and that's an Indiana 2009 Supreme Court case. And when we look at the issue before this court with regard to whether or not a credit or a set-off is important in this, we have to look at what the judgment of the court actually entered was in regards to. And the judgment in this case required the defendant to make payments pursuant to the uninsured motorist coverage. Therefore, we need to look at what the uninsured motorist coverage in the policy, what it actually says regarding credits or set-offs. And when we do that, and this is attached to my motion, I think it's also attached to Attorney Hawkins' reply and subsequent motions. When we look at the uninsured motorist portion of the policy, which starts on page 15, and then we go forward to page 22, we will see that there are language pertaining to credits. And the language pertaining to the credits, okay, and it says very clearly, any amount payable under the terms of this coverage, meaning the terms of the uninsured motorist coverage, which is what we're here for today and what the damages are related to, because of bodily injury sustained in an accident by a person who is insured under this coverage shall be reduced by. This is what is required. If these conditions are met, the award must be reduced. However, as we go on, we'll see that neither of these conditions are met. The first one, number 1, says all sums paid on account of the bodily injury by or on behalf of the owner or the operator of the uninsured vehicle. Well, the uninsured vehicle, they're not making the payment. It's Bristol West. Now, if the uninsured driver, if we were able to identify him, he would have forwarded us $10,000. Obviously, that would go towards this. We wouldn't have a $100,000 policy. We'd have a $90,000 policy. Or by or on behalf of any person or organization jointly or severally liable together with the owner or operator for bodily injury. Again, that's not the case here. Including all sums paid under Part A, which is the liability coverage of this policy. And the reason that's important is it goes to show you that these policies are very distinct and separate. We have liability coverage, Part A. We have medical payment coverage, Part B. And we have uninsured, underinsured, Part C. They're all distinct. We have to look to each one to see what they mean. So number 1 doesn't apply, so we know that they're not entitled to a credit or set-off as a result of number 1. When we go to number 2, it indicates the amount paid and the present value of all amounts payable on account of bodily injury under any workers' compensation law, disability benefits law, or any similar law. We're not dealing with either of those. Therefore, they're not entitled to a credit or set-off under number 2. And the last sentence there, it says no one will be entitled to duplicate payments for the same elements of damages. And the reason that doesn't apply, Your Honor, is this case is worth well more than $100,000. damages, Miss Austin's not being paid duplicate for the damages. Her case with the severe injury she had is worth at least $250,000, and that was what we had argued. Therefore, this isn't a duplicate payment, even though they paid under the Medicare policy. Now, when we look at what the defense has argued in their brief, and I'm assuming you're going to argue today, is what we need to look at is the medical payments, which is Part B, and that's found on page 11. And that doesn't apply either. And the reason being, so on page 14 is where it deals with the limits of liability. And it indicates right there, any amounts payable to an insured person under this coverage, again, this coverage meaning the medical payment coverage, shall be reduced by any amounts paid or payable under Part A, the liability coverage, or Part C, the uninsured, underinsured motorist coverage of this policy. It's very clear that under the medical payments, what we're looking at here is if a person, if this judgment were to require the defendant to make payments under the medical payment coverage, that's where this creditor setup would come into action. And that's not the case. And the fact that it's identifying Part A and Part C just goes to show you the importance that each one of these sections needs to be taken care of individually. Now, what the defendant has done throughout their motion and their subsequent motion is they realize that they're not entitled to a Medicaid set-off or credit. So in the alternative, they argue that they're entitled to a medical payment. And I've attached as exhibit number A to my response to their motion for the medical payment in showing you how the medical payment, this can't be a medical payment. And this is a letter from Farmers Insurance, which is a subsidiary of Bristol West. And it's got Bristol West identified there. And the real important paragraph is the second paragraph where it says, as a reminder, the policy under which the company made payments on behalf of and or to your client states, when Bristol West Insurance Company makes a payment under this policy, you're entitled to recover from another, or from you if you recover from another, up to the amount you pay. And that's very simple. It's like it is in any insurance case. If we were to collect a payment from another liable party, meaning either the uninsured hit-and-run motorist, obviously they would have a medical payment. But in this case, it wasn't another who's making payments. It is the defendant themselves, Bristol West. So this is just really has no play here. And based upon this, I filed a motion, Your Honor, arguing that I think the defense's position in this case is frivolous, unreasonable, and groundless defense, to which we are entitled to a reasonable fee for having to argue this. In a case that can be found to support that is KAHN versus Kundiff, 543 Northeast 2D-27. It's an Indiana Supreme Court 1989 case. And it's also found in statutory Indiana Code 34-1-32-1. And I've attached an exhibit indicating that I've spent 2 hours just responding to these frivolous responses of the defense at $250 an hour. That would be $500. In closing, Your Honor, what plaintiff is asking the court to deny defendant's motion for credit or set-off because there's no support in the statutory language. They wrote the language of the contract. If they wanted a set-off or credit, it should have clearly said that. That way, the plaintiff in this case could have known that they were contractually buying. Furthermore, plaintiff's motion for pre-judgment interest should be granted, and we are asking for an award of 8% for the 190 days, which comes out to $4,164. We're asking for the 8%, not the 10%. It's within the court's discretion, but we think that's fair because the pre-judgment interest is designed to promote settlement. And in this case, it's the defense that has delayed the case and sat on the money at the expense of their insured. And that defeats, the stalling defeats the purpose of the pre-judgment interest. Therefore, it is appropriate. As I said, with regard to the qualified settlement offer, we're not seeking that because even though there could be an argument made that once you tack pre-judgment interest on to the original judgment, it is now to a point where it is less favorable to the defendant. So we think we probably could get the $1,000, but we're not asking for that. But we are asking for the $500 for the frivolous defense in this case. So we're asking the court to enter an order for $4,564. Thank you, Your Honor.
Okay. Counsel?
The amount of the judgment was $100,000. The amount of the policy limit of the plaintiff, it wasn't for more than that and reduced to the policy limit. It was for $100,000. Now, with regard to the plaintiff's motion to enforce pre-judgment interest for the qualified settlement offer, I refer the court as in my response brief, the case of Pisarco versus Medulla. If you take a look at that case, the court has broad discretion whether to award pre-judgment interest, also to set an interest rate, also to set an appropriate time period, and the amount to calculate interest on. So theoretically, it could be less, for example, than $100,000. Now, in this case, with your discretion, Your Honor, I believe that prejudgment interest should not apply in this matter. And the reason being is that it is true, we did not comply with the particular statute in full. Section 34-51-4-5, as I cited in my response brief. However, the plaintiff doesn't deny that she was offered $75,000 before the hearing date on this matter. And that's more than 2/3 of what the actual judgment wound up being, about $100,000. Although it wasn't in writing, there are special circumstances in this case. We were defaulted on this case. We didn't have the benefit of any discovery on this case. So it's difficult to bring a basis for awarding or offering a certain amount to settle a claim. As you see, we've come up dramatically from the $25,000 as more information was available to us. So at this time, I don't see that the purpose of this prejudgment interest statute was not violated. We are technically disagreed that we are technically not in full compliance of that statute with the written offer, but as far as what was actually offered, we're in that compliance. And again, pursuant to Pisarco, the court has broad discretion on whether or not to award pre-judgment interest in this case. Now, as far as what the interest rate is, plaintiff says, we have no basis to suggest 6% on this case. Quite frankly, plaintiff has no basis to even suggest 8%, other than it's in the middle. Again, the court has broad discretion. Interest rates, it's well known since the recession that interest rates have remained very low. The U.S. prime rate hasn't budged from 3.25% for a number of years. Should the court, in its discretion, award prejudgment interest, I would suggest that a rate of 6% is appropriate. And as plaintiff's counsel explained, interest doesn't accrue until after 15 months after the date of the accident. In this case, 190 days is what plaintiff's counsel is looking at. Certainly, when the court awarded $100,000, we tendered that amount to the court. We're not holding up on payment on our end. Now, move on to the medical payments offset. We did pay out $7,750.25 in medical payments pursuant to the policy. Plaintiff's counsel does not argue that wasn't the case. As you see in my response or reply brief, I cite the Indiana law that an unambiguous insurance policy must be enforced according to its terms, even if those terms limit an insurer's liability. The contract of insurance will not be deemed ambiguous, will only be deemed ambiguous if reasonable people, upon reading the contract, will differ as to the meaning of its terms. If you take a look at the insurance contract with regard to the medical payments lien as part of the vehicle policy. Now, before I go into that, plaintiff's counsel stated that it was wrong for us to bring up this MedPay offset at this time. I would respectfully disagree with them. At the time, the court hadn't ruled on whether plaintiff was owed a penny on the uninsured motorist claim. Until that is the case, there is no offset. So really it is appropriate to be arguing it after the judgment is entered. And it would be like as if, again, plaintiff wanting to argue pre-judgment interest before there's a judgment. Now, as far as what is said in the contract is very clear, and it was read to you before on page 14. Any amounts payable to an insured person, that is Ms. Lindsay Olson, under this coverage shall be reduced by any amounts payable under, in particular, Part C, the underinsured motorist coverage of this policy. Now, in plaintiff's arguments, he brought up that no one will be entitled to duplicate payments for the same element of damages. We had the judgment was for $100,000. At this point, that $7,000 should be an offset. That has already been paid. If they get more than the $7,750.25, the plaintiff would be giving plaintiff more than what the court ruled on. And it would be a duplicate payment. So I would ask the court to offset that amount of the medical payments of $7,750.25. Now, as far as what plaintiff mentioned, a letter and attached to his response brief, but this isn't the insurance contract. As a matter of fact, it really doesn't talk about the underinsured claims. And again, this is not something in itself. This is a collateral source the court should look to the policy of insurance to get an understanding. And I think that it's really quite clear that an offset applies in this case. I've pled in the alternative that if the court doesn't find an offset under the policy, it would at least be a lien on any recovery. Now, again, it's just pled in the alternative. I didn't want to forfeit an argument, but I see this as an offset based on the language of the policy. It's clear, it's unambiguous, and the court should follow the unambiguous language of the policy. If the court finds that this is a lien, it would be roughly $5,000 $166.83 we would be entitled to. So that being said, I ask the court to grant defendant's motion giving us an offset to the award of $7,750.25 with regard to plaintiff's motion to enforce the qualified settlement order and obtain prejudgment interest. I request that be done. Thank you.
No briefly, Your Honor. First of all, I think the defense is pretty much agrees with me that they didn't comply with the statute at all regarding how to protect themselves. They made an offer of $75,000 the week of the hearing, basically an attempt to try to coerce Ms. Austin into taking less than what the cases were. The week of the hearing, it wasn't in writing, and they didn't do it within 9 months of filing the suit, so they didn't comply with the statute at all. And with regards to their comments that they really didn't know how bad the case was and there was no discovery, we supplied them with medical records, we supplied them with all the bills. They had all the documents, they had Dr. Cottage's notes talking about the concussion, we supplied them with school records. They were at the deposition of Dr. Cottage. They participated in that deposition. They knew how severely Ms. Austin was injured. Yet, after that deposition, they didn't increase their offer to $75,000. Rather, they waited until the eve of the hearing. Importantly, is they never even took the deposition of the plaintiff to try and hear how badly she was hurt. But with regards to the set-off of credit, the only portion in the contract that they're citing to is the medical payment coverage. And I think it's real important when we look at the specific wording that they chose, because we're not asking for a set-off of credit against medical payments. They're asking for a set-off of credit against uninsured motorists. And when we look at the medical payment coverage, it says any amount payable to an insured under this coverage, meaning payable under the MedPay coverage. It doesn't say anything about amounts already paid with regards to the MedPay coverage. Therefore, if they're arguing that somehow this applies a credit or set-off, they should have put it more clearly in their policy. If anything, this is very ambiguous, and I don't even think it goes to ambiguity. I think it just clearly shows that they're not entitled to a credit or set-off. This shows that if they are going to make future payments, any amounts payable to an insured person under the medical payment coverage, it shall be reduced, meaning payments under the medical payment coverage shall be reduced by any amounts paid or payable. And that's why it's important. They know the difference between paid and payable because they put it in the same paragraph under Part A or Part C. Therefore, we think we respectfully disagree. I don't think they're entitled to any credit, set-off, or medical payment. And as a matter of fact, they've already paid that to the clerk, and the clerk already forwarded to my office, but we're holding it in trust, and I thought Adam had actually filed a partial satisfaction of judgment, but I could be wrong in the title of that. So, Your Honor, we're asking that the court award, just real briefly, $4,164 in prejudgment interest, that's the 8%, and the $500 Thank you.
Anything else?
Yes, just a couple of issues. Plaintiff talked about coercion. I didn't see an offer of $75,000 to plaintiff as coercion. It's a reasonable amount, or what we felt was a reasonable amount at the time. As far as plaintiff's deposition, we were defaulted, Your Honor. You don't have the benefit of discovery in this case. We're defaulted. And thirdly, as far as satisfaction of judgment, plaintiff's counsel hasn't signed a partial satisfaction of judgment on this matter. This time, we've got a few extra issues here that will come before the court today to resolve after the court rules. Whatever has to be done thereafter, satisfaction of judgment will be signed.
Why is it you feel they don't have a lien on this, Mr. Bowen?
Well, because a lien, Your Honor, applies to another person. They can't have a lien against themselves. Typically what
I
happens
see.
is if I file a lawsuit against John Smith and my insurance company paid my medical bills, and then I get a judgment against John Smith, that's what a medical payment lien is. It's a lien against any recovery I get against him because it's unjustly restricted. And under our contractual agreement, I have to pay them back. But that's not what we have here. We have them claiming the lien, and that's why the language of the medical payment stuff is
So what you're saying is they have to pay under the MedPay provision and they have to pay under the uninsured motorist provision.
Correct. And they're paying, Ms. Austin paid 2 policy premiums for each of those.
Right.
And
Okay.
unless there's something in the contract that's specific, it's very simple. Where they had under the uninsured motorist, where they had the exclusions or the write-offs and set-offs, and they had the 2 different things, they easily could have put in there any amount payable under the med pay is to be set off against this. But they chose not to do that. And that's on them. And that's the policy that was purchased.
And your argument is you're stepping in the shoes of the other party, is that?
That is correct. It seems that plaintiff wants it both ways. Hindland benefits him, he wants it to be a single contract policy. But then that's those 2 separate premiums paid, he wants it separate. He wants it both. And the contract is for a med pay officer.
Okay. I don't know. All right, gentlemen, thank you. I'll get a decision out to you shortly.
Thank you, Your Honor.
All rise.